All right. Hello, everyone. Welcome back from the intermission. We previously just heard from our esteemed lead authors on our Therapeutic Jurisprudence Symposium. And now we're ready to move into our student authors, keeping in mind that our student authors didn't specifically write on this topic like explicitly, but we found that these comments and these case notes were at least somewhat tangentially related to this topic. And we wanted to give them the opportunity to speak and uh, get to share some of their insights. So without further ado, Jordan Robinson is here to tell us a little bit about her article. Jordan?
Oh, there we
Thank you, Derek.
go.
Can I share my screen real quick? I don't have slides, but I just want to put up my table of contents to kind of help me with the roadmap.
Sure.
Okay, so hopefully you guys can see this. So hello, everyone. Thank you guys so much for being here and joining us for the 2025 Symposium. And thank you guys for sticking around to listen to us student authors. I have had the absolute honor as serving as the executive student publications editor of the journal this year. And I am just so proud of the hard work that all these authors have put in. And I am incredibly grateful to the dedication of my student pubs team, my editors, Erin, Anita, Amanda, and Taylor, who have worked closely with each of these student authors and put in countless hours throughout this entire year to pull off all of this. I also want to thank Derek and Faye, our managing editor and editor-in-chief, for their hard work this year. I could not imagine two better people to work with in this capacity, and our journal would not have been able to accomplish all that we did this year without your guys' dedication. And lastly, I do want to shout out my friends and family who are able to make it on this call. And they have heard me yap endlessly about this article for the last 2 years. So thank you guys so much for making the time to support me today and every day. And briefly, before I get into it, I do want to give a bit of a content warning. My article discusses the application of self-defense doctrine to domestic abuse victims who have resorted to using violence against their abuser. So there will be fairly graphic and difficult aspects of this that I just want to foreshadow. But my comment, it is titled Sin, Sickness, or Self-Defense: How Medicalizing Women's Acts of Survival Confounds Justification and Excuse and Undermines Justice. My introduction, it starts off by discussing the case of State versus Norman, which is a fairly famous criminal case that we read in my first year criminal law course. And this case arose from a truly horrific case of domestic abuse. In the interest of time, I'm really not going to provide that much detail, and unfortunately, it's going to sort of blur over a lot of the nuance. But suffice it to say that Judy Norman was subjected to decades of torture and to some of the most brutal abuse imaginable. Not only was she physically, verbally, emotionally, sexually, and financially abused by her husband, she was regularly sexually exploited by him and violently forced to perform sex work. She had tried every avenue of escape she could think of. She had run away. She had called the police. She had tried to get protective orders. She had tried to get her husband mental health treatment. She had tried everything. And each of those attempts resulted in the abuse escalating. And it would result in her being just subjected to even more extreme violence. And I discussed Judy's case at relative length in my introduction. If you're interested, you can go there to read more. But one thing that was clear in my research is that Judy, her kids, and her mother, who also suffered abuse at the hands of Judy's husband, they genuinely believed that there was no escape for Judy or for any of them. And they were absolutely convinced that the legal system and the police and all of those institutions that should have been there to help them, that they either wouldn't or couldn't help them. And I really regret to have to skip over so much of the nuance in Judy's story, but eventually she did resort to using violence to defend herself and her family from her husband. One day, her husband went to take a nap and their grandchild started crying. Judy was scared of what her husband would do if he was woken up by this crying baby. So she took the baby down the block to her mother's house. And the few days leading up to JT, her husband's death, things had escalated for them. Judy had actually made a suicide attempt. She had been in the hospital. She hadn't slept the entire night. So she went to her mom's house. She asked for a pill for her headache. And then when she went to her mom's purse to look to find those pills, she found a gun there that her mom had obtained out of fear of JT, the husband. And Judy immediately took that gun back to her home and immediately shot her husband 3 times and killed him. Judy was charged with first-degree murder. She was not allowed to claim self-defense at her trial. And this is because when a criminal defendant wants to claim self-defense, in order to get a jury instruction to actually get that claim of self-defense in front of the jury for them to consider it, they have to show that they believed it was reasonably necessary to use that level of lethal force to protect themselves from an imminent threat of death or great bodily harm. So 3 main elements of reasonable necessity, proportionality, and an imminent threat. And for women like Judy, who have suffered years of cumulative violence, who end up resorting to such violence to defend themselves from an abuser, all 3 of these elements pose significant problems and barriers to them getting that jury instruction. And throughout my article, I use the term survival homicide to refer to these types of killings, where a victim of abuse has resorted to violence or ends up killing their abusive intimate partner or family member in self-defense. And you can kind of divide these into 2 groups of confrontational survival homicides and non-confrontational survival homicides. Confrontational ones, they occur in the context of an active battering incident or active abuse. Non-confrontational, that's like what happened in Judy's case, where he was sleeping, he was not actively battering her at the time that Judy used violence in self-defense. So in non-confrontational cases, courts flatly reject self-defense claims. They find that none of these elements of imminence, necessity, or proportionality are present. And in confrontational cases, the act of self-defense, it might be interpreted by the court as necessary and in response to an imminent threat, but for example, if a woman uses a weapon against an unarmed abuser, they're almost always going to be found to have used a disproportionate level of violence and then have the jury instruction denied on that ground. So just backing up a bit to like the basic criminal procedure of how this would go. When a defendant wants to claim self-defense, they have to plead not guilty and assert the affirmative defense of self-defense, meaning they basically say, I did the act, I admit to doing the alleged act, but for some reason, I am not criminally responsible for it. The judge would then decide based on the pled facts whether the defendant has shown by preponderance of the evidence that she's met these basic elements, made a prima facie case for self-defense or not. If the judge decides yes, then the defendant proceeds to trial. They get the jury instruction on self-defense. That goes before the jury, and the jury determines whether the defendant met those elements, the burden would be on the state to disprove at least one element of self-defense beyond a reasonable doubt. If the defendant is not granted that jury instruction, they have no defense, and they cannot present any evidence regarding the abuse or how it contributed to their act. Such evidence, it could only really come in the sentencing stage. And for that reason, almost invariably, a defendant in that position would take a guilty plea and try to arrive at some sort of plea agreement with the prosecutor. So circling back to kind of the elements of self-defense and specifically of why they are hard for women in these positions to meet, the first element is imminence. You can only use violence to respond to an imminent threat. And a lot of times, to be justified in using lethal force, the decedent or the person who is threatening the violence against, I guess, the eventual criminal defendant, they would need to be literally on the brink of killing the victim, the abuse victim, in order for them to be justified in using violence against the abuser. So for women, this poses some difficulties. You could imagine in Judy's case, if she had waited until a moment where he was literally on the brink of killing her, if she had waited until he was actively, violently forcing her to perform sex work, and then she attempted to use violence against him, it's not easy, or it's very easy to imagine how, you miss one shot, she has one try, and then you can imagine what might happen after that. So for the imminence requirement, a lot of women, they're not going to wait until that moment of it's literally on the brink. But even in the context of an ongoing battering incident, the proportionality element also poses difficulty. For all of these elements, they are judged by the reasonable person standard, which is supposed to be putting yourself in the shoes of the defendant and what would a person in their shoes reasonably, think is proportional or what's reasonably necessary. This standard, however, it really obfuscates a lot of the differences of when it comes down to men and women. And so, for example, if you would imagine two domestic partners in a verbal altercation, if the man begins advancing towards the woman unarmed, from an outside perspective, you might think it would be disproportionate for her to respond by picking up a knife or for her to use another type of weapon against him. But if there's a history of abuse where this man has previously choked this woman to unconsciousness on multiple occasions, it doesn't seem as disproportionate. But a lot of times courts do not adequately account for those sorts of things. Reasonableness, the reasonableness element, that is judged by both a subjective and objective need or necessity. When it comes to the subjective, that's normally is not so much of an issue, but the objective, judging from an outside perspective, how reasonably necessary it is, that's another area where these women struggle to convince courts that their act was objectively necessary or reasonable. In my article, I discuss the stand your ground laws as well. And so self-defense law, it imposes a duty of retreat. Basically, if you have an avenue of escape available, you must take that rather than standing and defending yourself using lethal force. The only exception to this has traditionally been the castle doctrine, which provides that when you're in your own home, you don't need to retreat. You can stand and defend yourself in your own home. The stand your ground laws have sort of taken this and expanded it to, the laws vary from state to state, but most of them essentially provide that there's no duty of retreat anywhere you have a legal right to be. Notoriously, the man who killed Trayvon Martin invoked Florida's stand your ground law to justify that murder. But although these stand your ground laws, they have really expanded the sphere of what is considered legally justified violence under self-defense, courts have almost blanketly, universally held that they don't apply to domestic violence situations where the people involved are cohabitants who both have a legal claim to the property or to the home. So all this goes to say that it is very, very difficult for women such as Judy, who have suffered cumulative years-long abuse, to be able to claim self-defense. Around the 1970s, defense attorneys got a bit creative and started putting forth some legal or novel legal arguments based on this theory of battered spouse syndrome, which I also discuss in my article. Battered spouse syndrome is a scientific theory. It's been fully discredited. It was never accepted by the psychiatric community. It was never included in the DSM or anything like that. It was based on this theory that women who suffer such extreme abuse, who endure the cycle of abuse, they end up developing a mental impairment or mental illness that essentially affects their ability to rationally assess risk and results in learned helplessness or just an inability to escape. This theory, I say in my article that I argue it's completely misplaced because it functions to medicalize women's acts of survival. Medicalization is a sociological term. It refers to labeling or construing human acts or behaviors as a medical issue when it might not simply be that. A example that I discuss in my article is homosexuality and how that at first, a long time ago, it was merely just a sinful act. It eventually became sort of a criminal act. Then it was viewed as a mental disorder. Whereas today we don't view it as a medical issue. We don't view it as a crime anymore. And it can kind of go both ways. It's not to say if something being medicalized or not, it's right or wrong. I think hyperactivity is another example of what is now called ADHD, used to just be bad behavior. And it has been medicalized and it's now considered to be a medical issue. All right, I'm coming up on my time. I'm getting a little worried, so I'm going to skip ahead. Basically, what this medicalization does is it conflates justification and excuse. Justification defenses are like self-defense, where you are saying, this act is ordinarily considered wrong, but in the circumstances, it's not. And for that reason, the person should not be held criminally responsible. The most basic example I think we all got in our criminal law classes was there's a fire raging towards a town. Someone burns a field of crops to create a fire break, thereby saving the town's residents. Burning crops would ordinarily be a crime. In this instance, it isn't because it was done to prevent an even greater harm. Self-defense, similarly, using violence against someone is ordinarily a crime. When you do it to defend yourself, it's not a crime because you're preventing the worst harm of an innocent person losing their life. Excuse defenses are things like insanity or that function on some sort of a diminished capacity to understand that your criminal act was wrong or was criminal. So battered spouse syndrome, it really conflates these two things. And it does so to such an extent that defendants in Judy's position are not able to really claim either kind of defense. When you raise a self-defense claim, you are asserting that your act was reasonable and necessary due to external circumstances outside of your control. But this syndrome narrative, it suggests that the defendant lacked a cognitive ability to understand that their act was wrong. So it almost requires these defendants to ask the jury to make just two fundamentally incompatible conclusions. Like at once that they are unable to rationally assess risk or respond to threats, that they've been so damaged by abuse that they have diminished capacity. But at the same time, a self-defense claim, it's asking the jury to also find that your act was objectively necessary and reasonable. And so how can a jury, find that the same act of defense was rational and irrational at the same time? And my argument is they can't. And that is what ultimately results in really unjust outcomes in these cases, that if a survivor, their act is not excused, it's not justified, that really only leaves one option for them to be found guilty of murder. So this, I argue, it's a harmful function of the medicalization of women's acts of survival. This medicalization, it's unjustified because the narrative of battered spouse syndrome, it implies that these women are weak and helpless and mentally impaired. And when women, you might have heard of the perfect victim, the idea of a perfect victim, that when women don't appear like what this syndrome narrative would suggest, of small and weak and so damaged that they can't stand up for themselves, juries discredit their claims. It's particularly harmful when, in the instance of women of color and Black women, who there's many harmful stereotypes, such as the angry Black woman, where Black women's conduct and behavior tends to be interpreted as aggressive and that sort of thing. And if a criminal defendant who's claiming they have battered spouse syndrome appears, argumentative or abrasive or anything other than just a small damaged mentally, like damage to the point of mental infirmity, that tends to undercut their claims. My ultimate suggestion is to entirely move beyond battered spouse syndrome evidence in general and in specific, and then generally refrain from applying medicalized language to criminal defendants. I also argue that due to the deficiencies of self-defense doctrine, a specialized framework is justified for these types of cases, where if a criminal defendant can show pretrial that by preponderance of the evidence that the decedent's abuse significantly contributed to their act of self-defense, they should be able to have a slightly different framework to account for those differences in how women have to defend themselves, to have a slightly different evidence framework to get in some more of that important evidence of abuse, and instead of labeling it as just syndrome evidence, give a more holistic social framework, larger evidence relating to a person's social background and relationships and how that contributed to their crime. Okay, I think I've already gone a few minutes over, so sorry about that, Derek.
That's all right. You're welcome to just wrap up if you need, an extra minute or two.
I think that's it. I think I got everything out that I wanted to say. Yeah.
Excellent. Well, thank you so much, Jordan. Awesome presentation. It was an awesome article to read and edit, and personally, I found it extremely thought-provoking because it puts victims in an interesting position where it's like, where do you feel like you need and have to use this sort of force to get out of it? So very thoughtful discussions. Thank you for that. So our next article, I believe, is from Erin Owen, and she's here to talk a little bit about solitary confinement. So Erin, take it away.
Thank you, Derek. And Jordan, that was great. You should give yourself a big pat in the back. I'm very proud of all of these authors right now, but I'm especially grateful for Jordan because she is, like she mentioned, the lead editor. So she had a big hand in making my article be amazing. So thanks, Jordan, and I'm very proud of you. So to begin, I want to just first say overall thank you to Faye, Derek, David, as well as all of the UIC Law Review Board for their amazing hard work and dedication this year. And I want to thank Anita and Jordan for helping me perfect this article and then for providing their insights to help me get published. So the symposium is only a small demonstration of how amazing this journal is, and I'm really proud to be a part of this. So thank you, everybody. So just to begin, hi, my name is Erin Owen, and I'm a 3L here at UIC Law, and I'll be graduating this May. So that's a very exciting last little wrap up for this month. I am on the UIC Law Review Board as a student publications editor. I'm also a graduate assistant here for the Restorative Justice Program at the law school, and I'm on the executive board for the Celtic Law Association and National Lawyers Guild. So after I graduate, I am proud to be able to join the DuPage County Public Defender's Office as an assistant public defender. So I'm passionate about criminal defense, restorative justice, and the rights of incarcerated individuals. So I really wanted my article to focus on these issues, and I appreciate everyone that has taken the time to read it so far. So my article is titled No Hope in Sight, Rethinking the Constitutionality of Solitary Confinement with Hope v. Harris. Now, to provide a little bit of background, as of May 2023, at least 122,840 incarcerated people are locked in solitary confinement across U.S. prisons and jails. Now, solitary confinement does not have a single definition, but it is typically understood to be the physical isolation of inmates where they're confined to their cells for 22 to 24 hours a day. They experience little interaction with other people, let alone society as a whole. And incarcerated individuals are among one of the most vulnerable populations within society. So solitary confinement really carries horrible effects that implicate constitutional issues. In the 2021 case of Hope v. Harris, Dennis Wayne Hope was subjected to over 26 years of solitary confinement in a Texas prison. In 1990, Hope was convicted of 5 aggravated robberies with a deadly weapon and impersonating a a public servant, which led him to being sentenced to 80 years in prison. Hope was able to escape prison in 1994 before he was recaptured by the FBI in 1995. As soon as he returned back to prison, Hope was placed in solitary confinement where he remained for over 20 years. In 2018, Hope filed a lawsuit against the Texas prison officials, arguing that his excessive isolation was cruel and unusual punishment under the Eighth Amendment. That was one of the main issues in his lawsuit. However, he did also argue 14th Amendment issues as well as a 1983 claim. So, the U.S. District Court for the Eastern District of Texas heard the case first and dismissed it immediately. And this is where Hope then appealed to the Fifth Circuit Court of Appeals. Now, like I said, the majority of Hope's claim really focused on the argument that his time spent in solitary confinement was cruel and unusual punishment. But this issue was addressed only in the footnotes of the majority's opinion. The court concluded in the footnotes that long-term solitary confinement is not per se cruel and unusual, and that the length of isolation sentences should not be considered within a vacuum. Meaning, solitary confinement is not cruel and unusual. However, the majority held that Hope was unable to allege that this Eighth Amendment violation was a violation because of the sheer length of time of 26 years that he spent in solitary confinement. And after the Fifth Circuit dismissed his claim, Hope filed a petition for a writ of certiorari to the United States Supreme Court on January 28, 2022. In Hope's petition, he asked the court to resolve the overarching issue of whether decades of solitary confinement can, under some circumstances, violate the Eighth Amendment as cruel and unusual punishment. 5 circuits currently hold that long-term solitary confinement can, on its own, without any other factors, violate the Eighth Amendment. However, there are 4 circuits currently that hold that long-term isolation is not a per se violation of the Eighth Amendment. Now, this split among the circuits is exactly why Hope petitioned the Supreme Court to have them rule on this issue of solitary confinement and finally decide the parameters of what constitutes cruel and unusual punishment. And Hope's petition urged the court to grant certiorari on the issue because he remained a part of a group of inmates that have been placed in solitary confinement for so long, with allegedly no end in sight. However, on April 17th, 2023, the court denied Hope's petition for certiorari, and the court did not even provide a reason for denying the case. So, why does all of this matter? Well, in refusing to hear the case, the court effectively furthered the divide among the circuit courts on whether solitary confinement can violate the Eighth Amendment as cruel and unusual punishment. Now, if we take a look back all the way to 1890 in the case of In re Medley, the Supreme Court held that the punishment of solitary confinement imposed a further terror that went above and beyond a death sentence. Yet here we are today, where solitary confinement is a widespread practice that is used in practically every single jail and prison across every state. The U.S. continues to rely on solitary confinement as a normal punishment for inmates, ignoring the multitude of studies that demonstrate that harmful and long-lasting negative effects that isolation wreaks on the human mind and body. Now, truly try to take just a minute to imagine yourself being placed in this type of situation and how little time it would take for you to feel the effects of isolation. Once an individual is placed in solitary confinement, the absence of human interaction is destructive. The part of the brain that's responsible for memory has actually been shown to shrink. And this leads to what's called social pain, which are the feelings of like hurt and distress that come from experiencing negative social experiences. And anytime someone spends time in solitary confinement, this raises the likelihood of death within the first year following an inmate's release. Now, these previously incarcerated individuals are also 24% more likely to die during their first year after release, including 78% more likely to die by suicide and 54% more likely to die by homicide. Now, previously isolated inmates are also 127% more likely to die from an opioid overdose in their first 2 weeks post-release. Isolated inmates experience chronic headaches, trembling, sweaty palms, extreme dizziness, heart palpitations, as well as hypertension, all as a result of being kept in solitary confinement. Now, the creation of supermax prisons across the United States has further allowed for the widespread use of solitary confinement. And there's no single group of prisoners that are actually immune from the possibility of being held in solitary confinement. If you so much as usher a word against a correctional officer, you have the option of being sent straight to solitary. And the United Nations has even condemned the use of solitary confinement for no longer than 15 days due to how irreparable the harm it causes. And it's hard to imagine the horrors that Hope faced after being isolated for 26 years. And prison officials rely on solitary confinement due to overcrowding issues, inadequate healthcare issues, and other unavailable services within the overall prison settings. So instead of placing incarcerated individuals in solitary confinement, other available means as other available means of society that we can look to should be implemented in order to protect the individual as well as the prison population. Organizations like the ACLU, the ABA as well, recommend keeping people in separate, safe areas of the facilities with others, and allow them to still have access to programming and facility services. Constructing individualized care plans with mental health professionals can also better address specific inmate needs. And if prison staff can better manage the needs of inmates, then inmates can exist in prison settings without the staff turning to solitary confinement as like a way to control their behavior. So ultimately, to abolish the pipeline to solitary confinement, prison populations must be reduced. Underprivileged groups should not be disproportionately criminalized. And it is genuinely possible for us as a society to move away from this barbaric practice. Imagine spending over 2 decades of your life in a cell no bigger than a parking space, alone for 23 to 24 hours a day. That was the reality for Dennis Wayne Hope. He challenged his solitary confinement as cruel and unusual punishment under the Eighth Amendment, but the Fifth Circuit rejected his claim, ruling that long-term solitary confinement was not inherently unconstitutional. Now, when the Supreme Court had the chance to weigh in, they refused. And this leaves this overarching question unanswered. So without any clear guidance, lower courts will continue to reach different conclusions, creating inconsistencies in how solitary confinement should be handled. Meanwhile, individuals like Hope remain trapped in the nightmare of isolation, with no certainty, no consistency, and worst of all, no end in sight. And I want to say I really appreciate everybody that has taken the time to listen and hear Hope's story today. And I'm more than happy to answer any questions that anyone might have. I know I probably did not go the full 20 minutes, but I hope everybody has an opportunity to read my article when this is all over. So thank you, everybody.
Yes, thank you, Aaron. Very, very good presentation. Um, and yes, we definitely have several minutes left if anybody is interested in asking a few questions. So I actually do have a question, just in case nobody else it doesn't look like. So from your perspective, are there any circumstances where solitary confinement for a long period of time might be necessary for, say, like a particularly psychotic prisoner or somebody that's committed like the most heinous, worst crimes? Or would you say that like there should be an absolute cutoff for all prisoners, regardless of, their behavior?
Thanks, Derek. I'll be honest with you. In my perspective, I'm gonna come down hard and just say I don't really think solitary confinement should really be an option at all. However, I do recognize that there are situations where people, could be in situations of sociopathic tendencies or, um, are damage to themselves or harm to others, where they might need to be placed in situations where they're away from others. But total isolation in and of itself is known to really be a damage to us as human beings. So if somebody is going through a big issue to begin with, whether that's mentally or physically, keeping them away from everybody else isn't going to solve the issue. So in my perspective, in my opinion, I would say no solitary confinement at all. However, I would have liked the Supreme Court to kind of give their opinion, which we unfortunately do not have here. We'll see maybe in a couple of years or so. Maybe they will decide it, but with the current court, I don't know if that's going to happen. But yeah, that's my perspective. Thanks, Derek.
Thanks, Aaron. And whoever else has questions, I think Professor Yamato raised first.
Yeah, thank you, Aaron, for your presentation, and congrats on your upcoming job. My first position was as a legal aid appellate defender in New York City many years ago. And so I'm excited for what you'll be able to do in your practice. So good luck with that. Um, I was wondering if you had any chance to look at how other nations regard capital punishment, and where does that put us on the scale? Because on so many other criminal justice scales, we definitely come out on the punitive side, comparatively speaking.
Yeah, 100%. Thank you, Professor, for asking that question, and I appreciate your little bit of encouragement there. That's awesome. Um, I did not specifically look into any research pertaining to like the outside world and how they really handle solitary confinement. However, I will say that my research did lead me down to the UN path, which I think it was UN Commissioner, I think it was Jose Mendez. I apologize if I get his name wrong, but he was the one that actually petitioned for this whole, marking of solitary confinement should not be longer than 15 days, period. And we are one of the countries that does not abide by that. I do believe that there are other countries that, do not take as much of a solitary confinement stance as we do here. But again, we have for-profit prisons within this country. We have these supermax facilities. So it's difficult because we're placed in a position where, jail is kind of a business here. And, if you can keep somebody in solitary confinement, unfortunately, that's how the way that society is going to keep pushing until us as a whole can look and really say we don't want to do this anymore. So unfortunately, I did not really do a whole lot of research on other countries or how it is across the world. But now that you raise that, I'm actually going to do a little bit of Googling after this is over.
Not a bad idea, if although I don't think that outside influences are particularly useful in US circa 2025. At least it might help keep you grounded as far as keeping perspective, right, on how the rest of the world regards this form of punishment. So anyway, good luck to you on that.
Thank you, Professor. I appreciate it.
Yeah. Mr. Kierstead. Go ahead.
Yeah, and I'm sorry, I can't find my, oh wait, did I get my hand up somehow? Yes, I
It
did.
recognized your hand
Did.
phrasing.
Oh, I see it. Sees the real thing. Um, got it. Erin, thank you so much. That's really interesting. And my question is a very uninformed one based just on something that I was aware of happening here in Canada a few years back. And that was a scenario where a prisoner who was really reviled by other prisoners, right? Like the crimes were really, yeah, quite horrendous, was placed in solitary confinement for his protection. And I wondered what your thoughts are on the use of solitary confinement in that. And I mean, not for 23 years or whatever, but for some not short period of time. And I wondered what you thought about that.
Yeah, that's actually very interesting, Professor. I'll have to, if you know the case or if you know any information,
I'll
please send
send
it
it
my
to you.
way. Yeah, because
Yeah.
I'd be really interested in looking at. However, I'm gonna come from the public defender perspective, I guess. And if that's what the client wants, that's what the client gets. Um, in my opinion, I still would come down from the perspective of like I don't want people to be in that position. However, it is important to recognize that there are people that can't necessarily function very well in other sociological settings such as prison, let alone society. So if somebody is in a position like that where they don't want to be around other inmates and they're also a danger to themselves, maybe there is a time period, probably, under the 15 days, like the UN recommends, that maybe they should be put in a situation not for total solitary confinement conditions where they're still able to access facilities, be able to go outside. Because that's also a big part of why isolation is so damaging is not only the social aspect, but also the fact that you're being taken away from regular prison. You might only have 2 hours just to get a shower, or you're judging your time based off when a meal comes through the door. You're kept in a position where you're not aware of who you are because of the conditions of solitary confinement. So maybe the social aspect should be reduced in a case like that. However, they should still be able to access the facilities, go outside, maybe attend the gym. But that's my perspective on that.
Thank you.
Thank you.
Great. Aaron, I think we have time for one more question, probably from the chat. Looks like there were a few. You can take your pick.
Yeah. I see Annette's first. So Annette asked, what comparison have I found with Hope or the like that support my paper on solitary confinement? And what information have you found with other countries that support your stance on solitary confinement? Find it slash Annette, what comparison? So, Annette, there are another group of prisoners that are across the U.S. that have actually been in these positions of these long-term solitary confinement issues. I cannot give you the exact number because I don't have it off the top of my head. However, Hope was part of this group of prisoners that also were saying, hey, we have these issues. We want to get out. This has been longer than 20 years. Something's wrong here. So there are other prisoners that actually do exist within the system that have unfortunately endured this long-term solitary confinement. And if you want to shoot me an email, I can go ahead and point you in that direction. And also, I kind of going off of Professor Yamada's question, I did not do a whole lot of research on the outside world as well. However, looking to, these questions here, that is something very interesting that I'm actually going to take a look at after. So if you want to connect after that, that'd be awesome.
Great. Thank you again so much, Aaron. Awesome presentation, great answers to the questions. And yeah, definitely gives everyone a little bit to think about, especially with kind of the long-term impacts of solitary confinement. So our next author is Isabel Beebe, and her article is discussing like the end of prison gerrymandering, and she can discuss a little bit more about that. So Isabel, whenever you're ready, take it.
Hi, guys. Thank you so much for taking the time to attend this symposium today and listen to all of us. I really appreciate it. As Derek said, my name is Isabel Beebe. I am a 3L and I will be graduating this May. I echo all of the thank yous that have already gone around. Thank you to all of my editors and especially Taylor, Jordan, Faye, and Derek, who helped with all of my final edits. Law review is not an easy process, as we all know, and having an editorial staff that was understanding, thorough, kind, and thoughtful was a really big help. I first learned about prison gerrymandering in my undergraduate course titled The Constitution and People of Color at NYU. It was in 2019, so we were looking at the ways before the 2020 census that the census can exacerbate and perpetuate the effects of racism by undercounting already disadvantaged populations via things like designated populations as hard to count, and of course, as I'll discuss further, prison gerrymandering. I was really struck by how something as kind of arbitrary and innocuous seeming as the census can be a tool for oppression. And I believe it's in these procedural details that often go overlooked that systemic injustices are permitted to continue. And that is why I wanted to expand on that research further with my article here. The title of my article is The End of Prison Gerrymandering. Has Illinois Done Enough to End Prison Gerrymandering by 2030? And apologies in advance if I stumble over the word gerrymandering as I'm about to say it probably 200 times. So, prison gerrymandering is the United States Census's practice of counting incarcerated individuals in prison instead of the communities that they lived in prior to that incarceration. This happens because the census is committed to its so-called usual residence rule that was in the act providing for the first census in 1790. The usual residence rule denotes that a person should be counted at their usual residence or the place where they live and sleep most of the time. And of course, when a person is incarcerated, they live and sleep most of the time at the prison. Because states use census data to complete their redistricting processes, prison gerrymandering distorts representation at all levels of government, local, state, and federal, and it often ensures that incarcerated individuals have no one looking out for their interests. Prisons are frequently located in rural areas, far away from where incarcerated individuals come from. Since 1941, every single prison constructed in Illinois is at least 100 miles away from Chicago. In 2017, 60% of prisoners in Illinois were from Cook County, and 90% of prisoners were incarcerated further downstate. And 95% of state prison cells are located in Illinois, are located in districts that are predominantly white. The result is more resources and greater representation for rural, predominantly white districts and less for the places that prisoners are coming from. The existence of a large prison population without voting power can have really extreme results. A famous example of this comes from a small town in Iowa called Anamosa, where one prison accounted for 96% of the population in the city's second ward. And in the 2005 city council election, a candidate won the second ward seat with 2 write-in votes, one from his wife and one from his neighbor. This just goes to demonstrate the outsized power that a voting population has in a district where prisoners are counted as the majority of the district. He could win with 2 write-in votes, and that's it. Additionally, legislators from prison districts are incentivized to oppose criminal justice reforms that could decrease incarceration rates because of the economic boom that prisons can bring to these smaller towns. They bring jobs, other opportunities, and prison jobs are often one of the best jobs in that area, and it incentivizes workers to oppose criminal justice reform and thus push their elected officials to oppose it as well. These effects are, of course, compounded by mass incarceration. The United States still has the largest prison population in the world, accounting for 5% of the world's population and 25% of the world's prisoners. And the system, as we know, disproportionately targets Black Americans. The 2020 census showed that 13.7% of the population identifies as Black, but of the 1,230,000 Americans incarcerated at the end of 2022, 32% were Black. Prior to the 2020 census, the Census Bureau hosted an open comment period in which, I'm sorry for all the stats, it's a very important part of painting this picture. The Census Bureau hosted an open comment period. They received 77,995 comments, of which 77,887 were about how the census counts prisoners. It is a popular movement that people, once they learn about prison gerrymandering, they do not like that the census continues to do this practice. But despite all of that, the Census Bureau maintained the practice of counting prisoners at the carceral facility, citing that 1790 Act saying that they need to be counted at their usual residence. But they did say that states can, on their own, decide to end prison gerrymandering in the state by requesting data from the census that will allow the state itself to reallocate the prisoners. But as I will discuss when we get to talking about Illinois, it places a large burden on the states to, first of all, request all of this data, ensure that the prison department is accurately collecting all of the data, and then eventually apply it to all of their redistricting maps while they're doing that process. So how does Illinois fit into all of this? In 2021, Illinois became the 10th state to pass a bill that attempts to end prison gerrymandering. The No Representation Without Population Act requires the Department of Corrections to maintain records on incarcerated individuals' legal residences that are not the carceral facility, and deliver that information to the State Board of Elections. And then the State Board of Elections must prepare redistricting population data to reflect those individuals' home addresses. Illinois passed a subsequent law in June of 2023, strengthening the act by creating stronger protocols for determining the last known address of individuals. Data collection is a really important part of this process to end prison gerrymandering, and it's proved to be one of the most difficult tasks for states that are attempting to end it. My article suggests that while Illinois has done a lot to end prison gerrymandering in the state, it has not yet gone far enough. The law currently enacted only ends prison gerrymandering at the state legislative level. The impacts of prison gerrymandering are also felt on the federal level, not to mention the local city council and school board levels. The Brennan Center for Justice found that prison gerrymandering exacerbates harms caused by other forms of gerrymandering and voter suppression, and has resulted in underrepresentation of communities of color in Congress. Additionally, implementation of the law was delayed until this year. Because Illinois completed a redistricting cycle in 2021, this means that prison gerrymandering will be in place until the next big redistricting cycle after the 2030 census. And this time delay was put in last minute. It was not originally part of a bill. And then in order to get this act passed, they had to agree to have this time delay implemented. So at the time the act passed, it was already guaranteeing another 10 years of prison gerrymandered districts. Additionally, I believe that increased transparency and community participation in the redistricting process in Illinois will help create more equitable maps and ensure an end to prison gerrymandering. In all of my research, there was a lot of commentary about how the Illinois redistricting process is kind of done in the shadows. It's not clear when meetings are being held that are supposed to be public. People will show up to the meeting and the doors are locked. Some solutions could include an independent redistricting commission, but this has been really hotly debated in Illinois. But in other states, it's been shown to be an effective way to create more equitable maps. And also in the states that have ended prison gerrymandering, it helps with the implementation of prison gerrymandering, as these people are dedicated to the redistricting process and are not politicians as well. As I conclude in the piece, the only real true end to prison gerrymandering will come when the census stops counting prisoners at the facility and instead counts them at home. The 9 states that ended prison gerrymandering before Illinois have encountered issues with the Bureau of Prisons delivering all of the data they need to properly reallocate those who were counted in the prisons. And these states reported that they were unable to receive inmate data at all at points, and sometimes they found a lack of quality in the correction facilities collecting and reporting of the last known address data, and it has led to difficulties in ascertaining where exactly to count incarcerated individuals, which just creates a whole other kind of mess, because if they're not being counted in the prison and they are not being counted in their home district, then in some cases people are not being counted at all by the census. In April of 2023, representatives introduced the End Prison Gerrymandering Act that would require the Census Bureau to count incarcerated people at their last place of residence. The act has currently not gone any further than introduction on the House floor, but if passed, it would end prison gerrymandering once and for all. The proposed legislation amends Title 13 of the U.S. Code to provide that individuals in prison for the purpose of the census shall be attributed to the last usual place of residence before incarceration. If this act passes, the injustice of prison gerrymandering will finally come to an end, but as it stands, it remains imperative that each individual state do everything they can to end the practice at a state level. Prison gerrymandering is one of the many ways mass incarceration has contributed to the oppression and disenfranchisement of minority populations in the United States. It is a small part of a large system that operates to silence those who capitalism and white supremacy work against. In this moment, where individuals that are legally in the United States are being deported to foreign jails without due process, and student protesters exercising their right to free speech are being targeted, it is more important than ever that we not ignore the ways, small and large, that our systems operate to control and suppress minoritized and vulnerable populations. Thank you so much.
Great. Thank you, Isabel. Fantastic presentation. we still have several minutes left if anybody has questions for Isabel. Yeah, the floor is yours. Yeah, Professor Kierstead.
Thank you, Isabel. I am going to confess, I was not aware of this whole concept. So this is such a good learning for me. Um, but I'm curious to know in your research, have you seen um, whether there's a lot of, is there a lot of motivation to affect the kinds of changes that you're talking about? Is there a strong movement currently? Or is
Yeah,
it a time where maybe not as much?
yeah, there really is. I think the problem is exactly what you started with, that people just don't really know about
Mm,
it. And
yeah.
I didn't know about it until I had to do pretty deep research into how the census can discriminate. So it's not something that you would think happens. It's not intuitive, I guess, is how I would say it. So it makes sense that people don't know about it, but when people learn about it, I have never talked to anyone that is like, oh, well, it makes sense that we're counting them there. I mean, it's imperative that these communities are represented and that they are still seen as a member of that community even while they're incarcerated, which I think just goes to more of an overall picture of how we view people that are incarcerated in this country, which we've already discussed, of course. But
Yeah.
um, yeah, they're when people learn about it, they are absolutely interested in ending it. I think that the census comment period coming up with almost 80,000 comments about this just shows that once people know, they are definitely invested in it ending.
So it's kind of a lot of the work is in getting that is the education piece,
Yeah,
right?
absolutely. Yeah.
How about it? Yeah, super interesting. Thank you.
Great. We still have a few minutes. There were a couple of questions thrown in the chat, Isabel, if you wanted to maybe take a stab at one of those.
Um, So I am not, I think, Annette, you asked if I am in support of gerrymandering. I am not. I think it's a complicated question in that overall it is a bad thing, but it is also used by both political parties in this country in rotation, depending on who is in power in each state. And so I think I'm not a gerrymandering expert. I'm a prison gerrymandering expert. But I will say in general, I think it is would be best for this country if districts were allocated based off of the population in that district, and that is it. I lived in New York City for 7 years, and I remember an example of just crazy gerrymandering to build Hudson Yards, to get the funding to build Hudson Yards. There was a really thin strip going up one street, and then I believe into the Bronx or something. Like there was a district in the Bronx and then one really thin strip going down to where Hudson Yards is, just cutting that out so that the Hudson Yards area could have the funding they needed to build that crazy hive structure, if you guys have seen it. But yeah, I think gerrymandering can be used for really nefarious means. And yeah, I'll read some more questions in the chat. Oh, Amy, thank you so much for sharing this link. Pull that up. How does prison gerrymandering affect political representation at the local and state levels? Thank you, Kenzie, for that question. So what happens is as I gave that example of in Iowa, so a prison is often in a more rural town, and that means the population is smaller. And when prisoners are counted in that district, then they are allocated more representatives often. They can be split into more districts because they are counted as having more people when really the voting population is much smaller than the number of people counted in the district. So it just results in people not like, and sorry, I'm a lot of talking. So then the prisoners who can't vote are not represented by the person who's elected in that county because I'm sorry, I'm really I obviously can't explain this. I did it for 50 pages. So prisoners are not represented by the person who's elected in that county because they cannot vote. They are more, and it's been shown that in their home districts, those representatives will often push for resources for those prisoners, even when that they are not technically the representative anymore. And the rural white populations have outsized voting power and more funding directed towards these districts because the prisoners are counted in their districts. I hope that made sense, even though I stumbled a little bit.
Absolutely. I mean, I followed it. So,
Thank
Professor.
you, Derek. Oh, Professor.
Yeah, so I think it just kind of hit me as far as one of the implications is that so if you are a prisoner in town A, technically you have elected officials in town A, but if you were
Hmm.
to write those elected officials in town A, um, they have no incentive uh, because you have no vote
Yep.
to take you seriously because we all know that the self-interest of what constituents feel is usually what influences some legislators' behavior, but it goes off, it can be ignored because there's that resident has no political power to influence that legislator's security of their seat, their reputation, or anything. It's
Yes.
something. So they're just being used
Yes.
as numbers.
Yeah, exactly. Exactly. Thank you so much for that. I think that is the part that's really crazy. And I
Uh,
found a lot of examples of the representatives in their home districts really advocating for the people in prison, even though they can't vote, they're not living there, they can't vote for them at that point. But because that is their community, that's where they're from, that's often where their family is from, then that representative is doing way more work for them than the place where they're being counted and the person that's technically representing them there.
yeah. Wow. Hmm.
Thank you so much.
Yeah, definitely a very messy business. Again, thank you so much, Isabel, for a great presentation, answering great questions. Um, and yeah, I mean, that actually leads us into our last speaker. Bethany Nelson is the Law Review's candidacy editor this year, and her topic is also related to domestic violence. So, Bethany, the floor is yours.
Hey, thank you, Derek, and thank you to the entire UIC Law Review Board for all of your hard work this year, and for putting together this symposium. And I would also like to thank all of my editors, so Aaron, Jordan, Faye, and Derek, for all of your hard work, and all of you guys helped make publishing this article possible. So I couldn't thank you all enough. Um, my name is Bethany Nelson. I'm a 3L at UIC Law, and I'm going to be graduating in a little bit over a month. This past year, I've had the honor to serve on the Law Review Board as the candidacy editor, and I've truly enjoyed my experience working with all of our candidates and together with the board. Um, so my article was also about domestic violence, so I just kind of want to give a little bit of a warning about that because I understand how this can be a very sensitive topic. So, my article was titled Family Violence and the Potential for New Remedies. And this article was about a case in Canada that proposed a new tort of family violence. And the purpose of this tort was to help compensate survivors of family violence. My article begins with some background about the topic. And again, I understand that this can be a little bit sensitive for some, but I think it's important to highlight some of these facts just to support the argument as to why this tort should have been implemented. So, domestic violence or intimate partner violence is a serious concern, not just in the United States, but it's a problem across the entire world. Um, and the statistics of those who suffer or who are faced with domestic violence is never super accurate because about 70% of cases actually go unreported to authorities. And this is for a variety of reasons, with one of the main ones being that a lot of times survivors of domestic violence don't feel safe reporting just because they are worried of what their abuser may do as a result of that. So, women, men, and children are all victims of domestic violence. And while there's procedures that are in place to help combat this, there's still a really large number of cases. And domestic violence is a pattern of behaviors that are controlling and coercive, and where the abuser then maintains power and control over the victim. And again, for this reason, it's also important to point out that I think a lot of a big conception people have is that domestic violence is physical, but it actually goes much further than that. Sexual abuse, emotional, economic, psychological, those are all ways in which people could suffer from domestic violence. And again, this can happen to anybody. And children face the repercussions of domestic violence as well if they grow up in homes where they are then exposed to it. So in the United States, in the 1800s, women could not do anything to protect themselves from their spouse if their spouse was abusive. And in the 1970s is when we started to begin to see a shift in that. And a lot of movements were created to help raise awareness for women in these situations and to fight for changes. Shelters started being formed as a safe place for survivors to go and isolate themselves and become in a safe situation. So coming from that, there have been remedies now that have been put in place for survivors of domestic violence, and one of those is the criminal system. However, some of the remedies that may be available for a survivor through the criminal system, they may not align with the remedies that the survivor is seeking. So in a criminal case, the state is the party rather than the victim. And if the offender is prosecuted and convicted, he or she may serve jail time or face other penalties, which this helps to also separate the survivor from the abuser, yes, but the system can often be inadequate and fail to provide survivors with meaningful redress. And in addition to this, the prosecution and conviction rates in domestic violence cases remain very low. Another problem with there is that not all acts of domestic violence are considered to be criminal, even though a lot of states are beginning to adopt some of these, they're not all. So not always does a survivor have a system that they could take. So the civil system is available. So this would give a victim a chance to hold control over the case. And it's also something because throughout the entirety of these relationships, a survivor they rarely have much control. So this is an opportunity for them to then be able to take control and take things into their hands. And there's the intentional torts. So there's battery, assault, intentional infliction of emotional distress. But an issue with these is that these can be barred by time because of a statute of limitations. And domestic violence is something that occurs over the course of a relationship, and it's never just a one-time instance. There's always more to it. So these remedies don't always capture everything that a survivor goes through. And additionally, even with all of these remedies in place, there's still a large number of cases that do not end up getting reported or people that do not seek out these remedies. So in 2022, the trial court in Canada heard the case Alawalia versus Alawalia, and the trial court proposed implementing a new tort called the tort of family violence. And this tort allowed victims of family violence to be compensated through damages. So the parties to the case were a husband and a wife. They were married in 1999 and they decided to separate in 2016, and they had 2 young children. So the father sought visiting time with the parents and weekending time, and through this, it came to light that there were instances of abuse throughout the parties' marriage. There were specifically 3 particular instances in where the husband had been physically violent with the wife. However, the court found that these particular instances only made up a part of the relationship that was filled with a pattern of conditioning and control. Not only was there 3 specific instances of physical abuse, but in addition to this, the husband would continuously insult the wife. The wife had difficulty conceiving children, and because of this, the husband would continue to insult and belittle her. and he would threaten on multiple occasions to leave his wife and their two children without any money. And there was another instance where the wife and the children, so the wife and the children were financially dependent upon the husband, and he knew about this, and he proceeded to leave and closed off any accounts, joint accounts that the wife had access to, so she was left with no money for herself or her children. So after taking all of this into consideration and the abuse faced by the wife in this case, the trial judge introduced a new tort of family violence. This tort was introduced as follows. A plaintiff could establish a defendant's liability through any of three modes. 1, intentional conduct that was violent or threatening. 2, behavior calculated to be coercive and controlling to the plaintiff. Or 3, the defendant would have known with substantial certainty would cause the plaintiff to subjectively fear for their own safety or that of another person. In addition to introducing this new tort, the trial judge awarded the mother $150,000 in damages. And this was to help the mother recover, as she would never, obviously, facing what she faced through, she could never be brought back whole again, as is what torts are for. However, this was to help the mother out as she was financially dependent on the husband and to kind of help with all of the things she had to go through, such as therapy and any doctor's appointments and things of that. So when creating this new tort, a significant focus was placed on the pattern of coercion and control rather than on the specific instances of conduct throughout the couple's relationship. And here it's very important to remember that domestic violence is a cycle that reoccurs over time. Again, it's not just usually one instance, it's multiple instances over the course of time, and they're not always going to look the same. And it's typically a cycle where the abuser will commit the act, and then they'll try to make everything good again and try to reconcile, and then they go back and do it again. And it's really hard then for the survivor to be able to exit the situation. So while the trial judge introduced this new tort, she did acknowledge that there were already existing torts under which the mother could take action. However, she was concerned that the actions would be viewed too narrowly if they were tied to just the specific instances, and this wouldn't then capture all the instances in which the mother was faced with the husband's actions. And so the judge was concerned that by viewing these actions in such a way that was so narrow that this would then minimize the harm which the mother was subjected to, or the wife was subjected to, because obviously it still is very serious, everything, but the trial judge wanted a way to be able to capture everything to make sure that the mother could receive compensation for everything that she had gone through, not just a few specific instances. So that was then appealed by the husband, and the appellate court struck down this tort. Their reasoning was that there was already the existing remedies put into place. And that, while that is true, this new tort actually had a broader range of liability, and this created a better remedy for those who are subject to family violence because of the three modes. Again, the intentional conduct was violent or threatening. This was the first mode of liability, and this captures the physical violence. So it would still be capturing that in addition to other torts that do as well. However, that's not the only thing that you could bring a cause of action for. You could also get behavior that is calculated to be coercive and controlling to the plaintiff. And this is oftentimes what survivors of domestic violence experience. They experience these behaviors by their partner, and where their partner exerts this control over them. And this could be in many different ways, emotionally, financially. A lot of times a partner will try to isolate the survivor from their families or take control over their lives. And then the third mode of liability, conduct the defendant would have known with substantial certainty would cause the plaintiff to subjectively fear for their own safety or that of another person. And this mode of liability is important, and I think that this is also very sets it apart from modes that are already available to survivors of domestic violence, because this talks about conduct that would cause someone to have fear, not only for themselves, but for that of another person. And I think that this is super important given um, how detrimental this can be on children who are grow up in homes where they are exposed to domestic violence. So if a partner is acting in ways in which the other partner believes that this could affect the safety of maybe one of their children, then they could bring a cause of action as well. And I think it's just these modes are more, they're broader and they capture more, and it doesn't need to be specific instances, but rather just like a pattern of things that someone is subjected to so that they can bring a cause of action. Um, Additionally, that what this tort did was for the wife, it gave her she was awarded $150,000 to help with any of the financial hardships which she had faced because of the abuse. And I think that this would be very important for people who are survivors to be able to have access to, because a lot of times when people are exposed or they're survivors of domestic violence, they have been physically harmed and emotionally harmed. So a lot of the times they have a lot of doctor's expenses, doctor's visits that have added up, or they're in therapy, so their therapy costs are adding up. And this could help kind of help them with some of that, as well as those who have faced financial hardships because of it. Something else is that a lot of people or a lot of survivors, they miss a lot of work, or they potentially lose their jobs because of the fact that they are being abused, because it's very hard on them, which then results to them not being able to go into work and potentially losing their jobs. So this would help make up for any type of that as well. And in addition to those who were financially dependent upon the person who was harming them. This tort also, if were to be adopted, should run for a longer statute of limitations, because for the first reason is that this would then give survivors of domestic violence more time to access safety before they bring a claim. Domestic violence is a very traumatic experience, and victims may not feel comfortable or safe reporting right away, which may ultimately lead to their action then being barred by any of the other tort remedies. And it's very important that the safety of the survivor and any other family members is prioritized in these situations. And for example, many intentional torts, you only have 2 years or so to bring a claim, and a survivor may then lose the ability to bring this claim because they might not feel comfortable or safe within that time. So I think that it's very important to prioritize the safety of survivors and make sure that they're given enough time to exit a situation and be able to have that safety before they're able to do anything. And a second reasoning as to why this should have a longer statute of limitations period is that domestic abuse can occur over the course of many years, and it can take a while for a survivor to be able to leave their abuser. So leaving an abusive relationship is extremely challenging, as evidenced by research that indicates that on average, a survivor makes around 7 attempts to leave his or her abuser before they're able to succeed in doing so. And this could be for a variety of reasons, whether they cannot safely leave at the moment. They may have children that they are taking into consideration. And the cycle of domestic violence can make it very hard emotionally on a survivor to be able to leave their partner or come to terms with how their partner is treating them. And until then, will they finally, maybe if they're able to safely leave the situation. So the tort of family violence introduced in Canada, I think, would create a great remedy for those who are survivors of this violence, as it's much broader and it captures more of the patterns of what survivors actually face. And I think additionally, having a tort with this name may make people more aware of the fact that this is a route that they are able to take to receive anything that they need. And I think that allowing for a longer time period for people to be able to bring these claims because of the fact that it may not be safe for them to do so right away is kind of unfair for them. Thank you.
Great job, Bethany. Congratulations. Awesome speech. And definitely, again, like everybody else that's presented today, a unique approach to handling some of the most sensitive issues that we have, in our society. We do have a few minutes left if anybody has any questions for Bethany before we wrap up for the evening. Professor?
Ah, thank you. I got to say, all four of the student presenters, you folks have done a great job. This is definitely a real enjoyable part of our program. Um, Bethany, I at times for different causes of action here, I've been concerned about overly short statutes of limitations, and in some cases have experienced in making being part of legislative advocacy efforts, the pushback against extending statutes of limitations. I haven't read your piece yet, but have you addressed what might be the resistance to that extended that 10-year statute of limitations? Because I think it's looking at the opposition that or potential opposition where you can make the most, ground, make up the most ground in terms of well, how should I say it? Looking at it from a standpoint of reality rather than the fact that most statutes of limitations are much shorter than this. Anyway, go ahead.
Oh, thank you. I actually did not really include what the resistance to that would be. I guess that's actually really something that would have been great to include in that. But I definitely agree that it is something that probably would face a lot of resistance. But I do think just the circumstances of these situations and the danger that people could be placed in if they do bring a cause of action sooner could maybe be a little more persuasive in an instance like that. Just because a lot of times it would be very dangerous for a survivor to do anything about the situation.
Thank you. And
Yeah, thank
yes, I'll say, as somebody who's done a lot of law reform advocacy, and this is not criticism, it's just advice. Always look at those oppositions, right? That's where the ground is, the battleground is to uh, see what that resistance is and to see how strong that resistance is, and hopefully to overcome it with good arguments. But again, cheers to you for bringing this transnational proposal into the possibility of U.S. law. That's a great thing. So that last comment is just as a general piece of advice. But thank you for your talk.
thank you.
Yeah, Professor Kierstead, go ahead.
Thank you. And I want to take this opportunity to sneak in my thanks again to Dean Campbell and to all of the law review team for giving us such a stellar experience today. Bethany, this question is a little bit related, but not directly on point, because I've been very interested in this Awalia case, but and in the development of coercive control as a recognized form of domestic violence. And I just wondered, one of the things that troubles me a lot is, regardless of whether we have a new tort or whether we try to use existing torts, it's really hard to prove, right? Coercive control, by definition, happens in such private ways and courts still look for, not to be crass, but like the hospital record, right? And I just wondered whether you have come across any anything in your research that speak to that kind of practical evidentiary difficulty?
No, I have not. And that is something that I was looking for, and I really wasn't able to find it. Because I do think it is unfortunate that that is kind of what is more looked for because there's so many deeper layers that you can't really always prove.
Yeah, exactly. And yeah, it's an ongoing area of concern, I think. But anyway, I thought maybe you'd found something I hadn't found. So thank you. Also, I'm going to send you a little link with some other info that you might find helpful.
Thank you.
Thanks
And if
very
I
much.
could
Great presentation.
add to what Professor Kirstead was saying, we've had similar challenges in defining what bullying is, right? Because again, you don't have the hospital record, right? And I think one of the challenges for all of us who recognize the harm of psychological abuse and mistreatment. And there's an interesting tie-in here because a lot of us who have been studying workplace bullying for many years have said it is closer in nature to emotional violence in domestic cases than schoolyard bullying. And so we all share that challenge of educating people of what are the patterns and the signs of emotional abuse when you don't have the bruises and welts to show for it. And how do we educate people to be able to distinguish between just a couple who's arguing a lot and a situation where there's genuine abuse going on at an emotional and psychological level. So it's a challenge for all of us, and you folks are going to be the next generations to address some of this stuff. So I can hand it off to you instead of having any magic answers on it, but it's certainly an important thing to consider.
Yes, absolutely. So thank you all for your insights and your questions. Kenneth did have one question in the chat, Bethany, if you wouldn't mind answering that, uh, and then we can wrap up.
Thank you, Kenneth, for the question. I actually did not, and that's actually a really great question to ask. Um, I definitely think it could help to support the self-defense issue because it would capture a wider range of um, ways which survivors have been faced with abuse. So I think that um, if that can be proved, it could really help to support the self-defense issue as well. Thank you.
Absolutely. I guess this kind of concludes the rest of our symposium. I mean, a huge round of applause to all of our authors, both our leads and our students, all around. This was a lot of work from a lot of different people, producing their articles, editing, going back and forth to make everything look good, sound good, cite well, everything in between. This really was a collective effort of everyone, I think, on this call. So, congratulations to everyone. Thank you so much for spending your afternoon with us. And we hope you have a great rest of your day and your semester. Thanks all.
Thanks again, everyone. This was a great day. We needed
Thank you.
it.
Have a good night.
Absolutely.